All right. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
Hey, good morning. Appreciate all of y'all being here. We are just going to dive right in if y'all are ready. Is the appellants ready? The appellees? Okay, Madam Clerk, if you'll call the case.
Case number SC 2024-0100, 790 Montclair, LLC, v. The Station at Crestline Heights, LLC, Valley National Bank, ARD Contracting Incorporated, Birmingham Metro, LLC, Alabama Hoops RE, LLC, Trinity Montclair 800, LLC, Trinity Montclair 820, LLC, and Birmingham Metro Baptist Association. Arguing for the appellant, the Honorable Carl Smiley. And arguing for the appellees, the Honorable Patrick Miller.
All right, Mr. Smiley, you ready?
Chief Justice Stewart, good morning, and may it please the court. Again, I'm Carl Smiley, and I'm here for the plaintiff, 790. This case is about the meaning and effect of an unambiguous easement. The trial court, it relied then on its misconstructions in denying 790's motion for a preliminary injunction. That was a legal error that requires reversal. Construing the meaning and effect of an unambiguous easement is a question of law. Even when reviewing a trial court's ruling on a preliminary injunction, this court reviews de novo the trial court's rulings on questions of law. And while the ruling on a preliminary injunction remains, the ultimate ruling remains subject to an abuse of discretion standard, if this court concludes on de novo review that the trial court relied on erroneous legal rulings in exercising its discretion, then its discretion was abused. That's where this case is. Also, because the trial court's construction of an unambiguous easement is a question of law, it's entitled to know that ruling is entitled to no presumption of correctness under the Ori tenants rule.
So I wanted to ask you, we're here only on a preliminary injunction appeal, right?
Yes, Your Honor.
And so under Rule 65, the case law is you've got these four factors for determining a preliminary injunction, right? It's equity, right?
That's one of the factors, true. Yes, Your Honor.
And one of those factors is the balancing of the equities, right?
Yes, Your Honor.
So I've seen pictures in the record show this project that the appellees have is basically complete. Is that right?
That is my understanding, yes, Your Honor.
And they claim they've spent roughly $60 million on this project, right?
They claim that, yes, sir.
And I looked in the record to try to see, well, what was your harm? Because we got to balance the harms, right? And I see an answer from your primary 30B6 corporate representative basically says he doesn't have to identify what his harm is, and he doesn't say what his harm is. So help me balancing the equities here. I mean, it seems like there's an abuse of discretion review. This judge didn't abuse his discretion on this balancing the equities here.
Well, Your Honor, thank you. And before we get to balancing, there has to be a determination of what is being balanced. Okay, what is on one side of the scale and what is on the other side of the scale. And because the trial judge misconstrued the easement, he put in effect what used to be these styrofoam packing peanuts on 790's side of the scale, and then he's got other things on the other side of the scale. But the first issue is what is the property interest that 790 has, and it has an easement interest. And this court's precedent are that interfering with a property interest is irreparable harm that cannot be adequately addressed.
But that's a different element, right? We're talking
That is-
fourth element is the balancing of the harms. And so I'm like, what's the harm to your client?
The harm to 790 is that its property rights under the 2018 easement have been infringed. And it matters a lot to 790 to have its property right in that easement correctly construed and enforced. There are other lots up the hill on Dan Hudson Drive where this issue could arise again. And so it's very important to 790 to have its interest properly recognized in the trial court, properly construed and enforced.
Is that only because of precedent?
Or,
Is that only because of the influence on other people doing cuts in the curb?
well, that's certainly a big reason. But again, Your Honor, in enforcing a property right, there is an inherent harm in not in letting someone infringe on it. If someone cuts across my yard regularly to take a shortcut to school, okay, I'm not really harmed by that, but I have a property right and I can insist that they not do that.
But you could have stopped them if you had paid the bond on the TRO before they built all this stuff, right?
Well, according to the station, the project was already well underway by the time the TRO was granted, and it was temporarily stopped. They could have stopped it to wait and see, what came of the ruling on this, but they did not. And their use of the property, the need for an entrance on Dan Hudson Drive is because of their peculiar use of the property. They have access to 52nd Street. It's not like they've got a landlocked parcel, but they decided to build a particular type of project with 277 apartment units. And that's why they wanted to have this main entryway installed on Dan Hudson Drive.
But just to be clear, there was a TRO in place for a period of time and they stopped work on their project.
Yes, sir. That's correct.
And at that point, they had basically done site prep work.
According to them, they'd done a good bit, about $4 or $5 million or $14 million worth of work. But they had done a good bit of work, correct?
But not 60 million of work.
That's correct.
And then the court increased the bond and your client chose not to pay the increased bond.
I think there are a couple of intermediate steps, but you get to the same place. Yes, sir.
And so after you didn't pay that increased bond, then the appellees went to the trial judge and said, hey, please say that the TRO is no longer in place because he didn't pay the bond. And the trial judge said, that's right. It's not in place because they didn't pay the bond.
That's correct.
And then they went and spent the rest of the $60 million.
Your Honor, I think they were already spending the $60 million before they went back to the trial court and asked that the TRO, in effect, be acknowledged to be no longer in effect because the bond wasn't posted. They continued the construction.
They didn't violate the TRO.
Pardon me?
They didn't violate the TRO when it was in effect, right?
They continued the construction. They just did not use the access off of Dan Hudson Drive. The construction kept on going. So I'm going to start with some minimum background facts. I know we got a long record and I'm going to try to keep it short. Please help me out and truncate this if I'm going into something I don't need to be going into. But this story starts in 2005. Okay, when the Baptist hospitals split their campus into two pieces. They conveyed one parcel, the parcel to the west of Dan Hudson Drive, to a new related entity, Baptist Hospital Systems Properties, BHSP. They kept the other parcel, the other side. And when they did that, they imposed an easement, or a reciprocal easement, on a lot of the infrastructure around the campus. Fast forward to 2018, new easement, the 2018 easement. That's the easement we're really here on now. Okay. The 2018 easement imposed some additional and different requirements on use of infrastructure on the property. At the time the 2018 easement was granted, the whole eastern parcel, the parcel owned by BHS, had access to Dan Hudson Drive. Okay. But then in 2000, Birmingham Metro purchased that whole parcel, and then they subdivided it into a number of different lots. And when they subdivided it into those lots, some of the lots were cut off from vehicular access to Dan Hudson Drive. And then in 2021, the station purchased one of those lots, and it purchased a lot that was cut off from Dan Hudson Drive by the subdivision. They wanted to build this big 277 unit apartment complex, and because of the configuration of their development and the size of it, Birmingham required two means of vehicular access. They only had one. So what they did was they destroyed about 40 feet of the sidewalk and curb, put a new main entrance to their apartment complex there, and replaced the curb and sidewalk with a crosswalk. Okay. And the 2018 easement has some things to say about that are important. And before they did that,
What are your damages as a result of that? I mean, they've done these things, and let's just say if we can see that, what are the damages for them taking this 40-foot cut off the curb and putting a crosswalk in?
again, Justice Sellers, the damage is 790's property rights have been infringed. Again, and go back to my just
Right.
simple
So, okay.
example.
So they've been, you're damaged that way, but can you quantify what those damages are? So if we were to agree with you, what relief are you asking us to give you?
That, and I appreciate that question
I
about.
mean, I hate to cut to the chase, but
No, I appreciate the question. So on the relief, what we're asking for is this, and what we have asked for is this. We need a ruling that access facilities as used in the 2018 easement includes that sidewalk and curb that the station demolished and replaced. All right. That's what access facilities means. And it includes all private drives, pedestrian bridges, and sidewalks located on the parcels, not just the little piece that's shown on Exhibit C, but that follows including but not limited to. It includes all pedestrian bridges, private drives, and sidewalks located on the parcel. So we need that because the trial court misconstrued that. He got it wrong. And so now we have a ruling out there that says the easement means something that it doesn't say. We also need a ruling that says that the trial court got it wrong when the trial court imposed a materially interfere standard on showing that 790's consent is required. The actual terms of the easement, I see my yellow light's on, so let me see if I can do this real fast. The actual terms of the easement says, section.
I don't interrupt you, but we've got that out of the brief.
Okay.
So what I'm concerned about is, among other things, is Exhibit C, and I understand your point that Exhibit C is not everything,
Yes, sir.
but Exhibit C was drafted by your side, right?
Exhibit C was developed by, as I understand it, by a lawyer who was representing 790 Montclair.
Which is your client.
Correct. Yes, sir.
And so I'm looking at, I think it's the second chart over there, but it's document 4931, and it's drawing, I think, of Exhibit C with Baker Donaldson's name on it. And Baker Donaldson was the lawyer for your client in this transaction, right?
Yes, sir.
So they drew Exhibit C.
Well, yes, sir. That's correct. That's
And
actually
the
correct.
curb and the side in your property is on the other side of the street from from the station's property, right?
It's on the other side of Dan Hudson Drive, correct?
Right. And so the cuts in the curb and the cuts in the sidewalk are on the other side of the street from you, right?
Yes, sir. It is.
And Exhibit C doesn't have the curb and the sidewalk on the other side of the street drawn, right?
That's correct. But the restriction that we're seeking to enforce, Section 3A, applies to sidewalks located on the parcels. The parcels is the whole shebang. It's both sides. And Exhibit C follows the phrase, including but not limited to. And everybody in this courtroom knows, in gallery, everybody knows what that means. So it's not limited by Exhibit C. And my light's on, so.
Your time is up. Do you want him to finish? Let's go.
I don't want to take up your time. If you've got a point to make, please finish. So
I was pretty close to being finished. I'll do the rest on rebuttal. Thank you.
Good morning. May it please the court, I'm Patrick Miller, and I have the honor to represent the appellees in this case. As Justice Cook has already stated, the only issue before this court is whether or not the trial court abused its discretion in denying 790's request for a preliminary injunction. That is the only issue before this court. And the trial court did not abuse its discretion, as we have displayed and set out in our brief. It's important for the court to understand, after hearing Mr. Smiley talk about property rights, that my client, the station, and the other owners have property rights. In fact, the 2018 easement gives the station an express easement for ingress, egress, and access using Dan Hudson Drive. So under the document in question, we unambiguously—
where does it say that?
In Section 2A of the reciprocal easement. As a matter of fact, Justice Cook, the purpose of the 2018 easement is to provide the owners, such as the station, with access for ingress and egress to Dan Hudson Drive and the other access facilities that are depicted in Exhibit C. So the trial court balanced all of the property rights of the parties in coming to the conclusion that it arrived at. And it is crucial for the court to understand that the station and all the other owners have an easement for ingress, egress, and access to Dan Hudson Drive. Now, to use that easement, we have to make a curb cut and we have to make a crosswalk. Otherwise, theoretically, we could drive across the curb, but that would not be practical, of course. A curb cut and a crosswalk are reasonable and necessary for the use of our easement and have no impact whatsoever on 790's access to its building. The 790, however, filed a preliminary injunction request seeking to block the station's right to use Dan Hudson Drive. So unlike a lot of injunction cases involving easement, what the plaintiff was trying to do is get an injunction to block the station from accessing a road that it had an express easement to use. So it is really the reverse of ex parte Folsom and some of the other cases that humble dirt lawyers like me have been arguing easements about in the state of Alabama for many, many years. Additionally, when 790 was asked why it wanted to block this curb cut, its 30B6 representative said, "It's my desire, and it's irrelevant." Additionally, this 2018 agreement has a provision, the easement agreement, that says, "Notwithstanding anything herein to the contrary, an owner like the station shall have the right to use these easements," which include Dan Hudson Drive, "as long as they do not materially interfere with the use and enjoyment of the other party's easements." And the very first witness that 790 Montclair called at the trial of this case was its own Louisiana lawyer, Ann Raymond, who offered extrinsic evidence testimony about what the intent of the parties were. But one of the things Ms. Raymond admitted on cross-examination was the fact that as long as the station did not materially interfere with the use and enjoyment of 790's easement, we had the right to access Dan Hudson Drive. She admitted that. And over 4 days of testimony, and 1,100 pages in the transcript, and over 100 exhibits, most of which were offered by the plaintiff, which now says there's no facts in dispute. The trial court determined that there was no evidence that 790 presented that the station's curb cut and crosswalk would materially interfere with the 790's easement rights. The trial courts.
So let me ask you, I understand this clause in section 2 that you're citing to, the notwithstanding clause. But the access facility seems to be a carve out of that notwithstanding clause. The notwithstanding clause provides you easement rights and rights to use your easements as long as you don't materially interfere with other people's easements. But then the access facilities clause in section 3 seems to be a carve out of that notwithstanding clause to me. So let me ask you about this clause they've cited in 3 that I see as a carve out. And one way to read it is it's the access facilities that are depicted upon Exhibit C. Another way to read it is it's all access facilities, including but not limited to the stuff on Exhibit C. So help me understand the grammatical argument here about why you're right in construing that, what I call a carve out in section 3, and they think means everything that's on the whole parcel.
Justice Cook, before getting to the grammatical side of that, let me just reiterate that that is just one part of the trial court's multifaceted analysis for a preliminary injunction, which I know you appreciate. But getting to the grammatical side of the argument and the textual side of that argument, what that provision says is, backing away a little bit, the easement agreement, section 2A, has an express provision that provides my client with an easement for ingress, egress, and access using Dan Hudson Drive and the other facilities. Then it has a provision, and as practitioners, we're all kind of aware with this, where you're trying to make sure that you cover all your bases, where you say, notwithstanding anything herein to the contrary, the owner shall have the right to use the easement areas, which include Dan Hudson Drive, for the purposes set forth in this section 2, as long as they do not materially interfere with the use and enjoyment of the easements. Now that says anything herein. It doesn't say anything in this section. It says anything herein. And as a lawyer, when I put in anything herein, I'm trying to cover myself and my clients to make sure that if there's any dispute about anything having to do with the meaning of the priority, that this trumps any language in the contrary. And Justice Scalia and Professor Gardner have agreed in Section 13 of Reading Law. They look at the provision that says notwithstanding. And on page 127, Justice Scalia and Professor Garner wrote, quote, "But the catch-all notwithstanding is a fail-safe way of ensuring that the clause it introduces will absolutely, positively prevail." That's about as unambiguous as it can be. So that's
I gotta harmonize this. Okay, I got the notwithstanding clause. I got your argument. How do we harmonize that with the provision on access facilities? And then how do we read that access facilities to whether or not it's Exhibit C or something more than Exhibit C?
Well, in terms of harmonizing, that's where you have to get back to balancing, because what we're looking at here is a preliminary injunction. But in terms of harmonizing the document internally, again, that's only one aspect of a multifaceted analysis that the trial court conducted. But if you want to harmonize that, as you must, you have to look at the notwithstanding provision as trumping anything else in the document, regardless of whether or not there's an alteration, regardless of whether or not anything else to the contrary, as long as we are not materially interfering with the use and enjoyment of the easement. And so even if there was an alteration, or if the court were to find that there was an alteration, we're still talking about 40 feet of curb that is 700 feet away from the 790's driveway to their property. Doesn't have any impact on their right of ingress, egress, or access to their property. So under those circumstances, if somehow the 790 were able to prove damages, as you had asked about, Justice Sellers, they could, if the court or the trial court ultimately determined that their request or that their interpretation was correct, they could be entitled to some incredibly nominal amount of damages. But at the same time, the trial court quite properly determined that injunctive relief was not proper here. And that is a decision that is justified by looking at numerous cases that this court has decided in the past. Most on point to me is the Alabama Power versus Drummond case, in which a homeowner named Drummond had apparently placed part of his or her lake house in a flood easement owned by Alabama Power. So the trial court and this court ultimately affirmed that even though that was a minor infringement of an easement, it was not sufficient to justify injunctive relief. So you don't move a house because of a minor infringement. Just so in this case, you wouldn't stop a $60 million project because somebody removed a curb and improved it, frankly, by making a better, a safer access into Dan Hudson Drive. The trial court properly exercised its sound discretion in determining and in weighing and balancing the equities and hardships in determining whether or not injunctive relief was proper. In Westtown Plaza and Associates, this court stated, versus Walmart, this court stated that it was quite proper for the trial court to make determinations and to weigh and balance the equities when it came to such decisions, and it would not be reversed unless it was an abuse of discretion. As stated previously, the harm that the station would incur if the preliminary injunction were granted would be existential. Why? The station has to have two means of ingress and egress. This is just a safety matter that the city of Birmingham requires. When the station purchased this piece of property, it was assured by attorneys that were representing it, and furthermore, who were representing its lender, that it had access and had the right to access Dan Hudson Drive. And those interpretations are in the record. They came through other testimony in addition to the affidavits that were offered and submitted to the trial court.
So if we're looking at this abuse of discretion, which we all agree that's what we're supposed to do, the abuse of discretion, it's analyzed, takes place in a particular time when the court is looking at what's going on. We now have however many years past, things virtually complete or substantially complete or whatever it is. In looking back to abuse of discretion, can we consider what's already happened? And I ask that because it doesn't seem like there is an available remedy at all for 790. I mean, I'm not sure what we could do. So can we look at abuse of discretion with information we know now and relate that back? Or are we stuck with what the court had only at the time it was called on to grant the preliminary injunction?
Well, going back to that, Justice Sellers, at the time that the temporary restraining order was entered, which prohibited the station from accessing Dan Hudson Drive, which is a curious situation when you consider that we have an easement right to Dan Hudson Drive, but that was the order that was issued. When that was done, the station had already spent $14 million on this project. It had already built 4 buildings, cleared the ground, of course, and made a connection into Dan Hudson Drive. The station, 790 waited 7 months before taking any action to seek injunctive relief.
Can we consider that when we're analyzing abuse of discretion of what those facts were at the time they asked for one versus the 7 months that went on? Because it seems like it's extraordinary to have a multi-million-dollar facility and there's an easement problem. And if we were to say the court did abuse its discretion, I can't figure out what the remedy is that we could possibly grant that would be significant enough to, quite frankly, justify some of the discussions that we're having. But that's just me.
Right. I agree, Justice Sellers. And I understand what you're saying, Justice Sellers. And you go back to when the temporary restraining order was entered and stayed in effect for several months, the station was prohibited from accessing Dan Hudson Drive. So what it basically happened was it could only access 52nd Street as part of the construction. And this caused a substantial amount of damages. But going back further, Justice Sellers and other members of the court, if 790 had filed for an injunction as soon as the curb cut was made 7 months ago, it would have been a wholly different situation than it was after 7 months had passed, after the city had approved the station's plans, after 4 buildings had started to rise up from the ground. So when the court actually issued its order denying the preliminary injunction, the buildings were, for all intents and purposes, complete. But 790 ultimately, at some point in time, stopped or refused to pay the heightened bond that the court asked for. So as a result of that, the temporary restraining order went away. But if you look at all of the balancing, it's not a close call. You've got $60 million on one hand, and you've got somebody else saying, it's my desire. And that's the extent of it. The curb cut and sidewalk, as we've discussed previously, are not part of the Exhibit C and are not depicted in Exhibit C. And as a result of that, they are not part of the access facilities that come under the Section 3A. But even if they were, again, that is one part of the trial court's decision. That is one facet of a larger series of issues that the trial court looked at in deciding injunctive relief. And here's another fact about that. If the curb cut and the sidewalk were so important to 790, they certainly could have depicted it on Exhibit C. They failed to do so. Their lawyer drafted it. Their surveyor provided the underlying survey for it, and it was not important enough for them to even put it on Exhibit C. And now they're asking.
So what is left in this case?
There is a preliminary injunction that has been denied. There is a claim for a tort claim against 790 for tortious interference. And there is ultimately a decision for the trial court to make about whether or not a permanent injunction should be entered.
A tort claim by your side against them?
Yes, sir. Yes, sir. Finally, but the trial court also determined that a curb cut and crosswalk are reasonable and necessary for the use of the 2018 easement. This court in Toomey versus Riverside RV Resort stated that even though a culvert was not expressly called for in an easement agreement, the culvert was reasonable and necessary for the use of the easement. Likewise here, a curb cut and ADA-approved crosswalk are both reasonable and necessary for the use of the easement in question. With regard to getting back to Exhibit C, there are numerous citations in the briefs of the 790's briefs to Reading Law, Professor Garner's book, and Justice Scalia's book, of course, and Garner's Dictionary of Legal Usage. None of those citations were argued to the trial court. So how can the trial court commit an abuse of discretion by not following citations that were never presented to it? I would submit that it can't. 790 will not suffer irreparable injury if the station is allowed to exercise its easement rights over Dan Hudson Drive, because the station and the other appellees are not seeking to block an easement. On the contrary, as I mentioned previously, it is 790 that is seeking to block the station's easement to Dan Hudson Drive, an express easement. So blocking an easement can sometimes justify injunctive relief, but that is certainly not the result of the trial court's order here. the station, in effect, was, or 790, I should say, sought to block the station from using its easement, which the trial court denied. Now, in West Town Plaza, the court held that an encroachment and an easement was in a place uniquely essential to the purpose of the parking easement in question in that case, and thus awarded injunctive relief. But that's a different situation here. 790 obviously has not proven and has not offered any evidence that this curb and crosswalk 700 feet away from their property on a road that they do not even have direct vehicular access to. I may not have mentioned that. 790 does not even have direct vehicular access to Dan Hudson Drive. So, in West Town, the court determined that the encroachment was in an area that was uniquely essential to the purpose of the parking easement. No evidence has been presented by 790 that this curb and this crosswalk are uniquely essential to the purpose of 790's easement. Quite the contrary, there's been no evidence. And from the questions that the court has asked, I understand that there is a question about what 790, what is their motivation here? And I can't really get into that for reasons. My time is up, Madam Justice, or Chief
You want to
Justice.
finish your sentence?
I'll try.
Okay.
But what I could say is this. This case is not about property rights. This case is about a preliminary injunction that was quite properly denied by the trial court after weighing and balancing my client's easement rights as well as the catastrophic harm that it would incur if injunctive relief were granted. Thank you.
Thank you, Mr. Miller. Mr. Smiley?
Thank you again. Let me try to address three issues that came up. One is the issue that Justice Cook raised about the carve-out for access facilities and reconciling that, and a lot of talk from Mr. Miller about notwithstanding. All right, so you have to look at the document, all of it. And Section 2, which has the materiality language in it, begins, subject to the other terms of this agreement, including without limitation, Section 3. So Section 3, which has the prohibition against the curb cut, Section 2 is subject to that prohibition. And then you get to notwithstanding anything to the contrary herein, which is in Section 2, which is subject to Section 3. Here's how the harmonizing works, is if you construe, as you should, herein to mean Section 2, which it's certainly, that's a very common meaning, is here in this section, not the whole agreement. Then you harmonize Section 2 and Section 3. Then you harmonize subject to with notwithstanding anything to the contrary herein, because herein only applies to Section 2, not Section 3. And the Scalia and Garner treatise that Mr. Miller cited about the power of notwithstanding has the same thing, which is in our brief, for subject to. It subordinates everything. So you've got two equally compelling terms, but they're easily harmonized by restricting herein to Section 2. Then there's not a problem.
Do you agree with my characterization that Section 3 access facilities is a carve-out of the broader notwithstanding clause that governs easement areas, I believe is the word, in Section 2?
Section 3, Justice Cook, deals with alteration, removal, and construction. So Section 2 is a grant of easement. Section 3 talks about what you can and cannot do with that grant. And Section 3, and it's different depending on the type of easement involved, but 3A says access facilities shall not be altered, relocated, or removed without the prior written approval of all owners, which approval may be granted or withheld by each owner in its sole and absolute discretion.
And the access facilities is a subset of the easement areas.
Correct.
Okay. And so the
Correct.
question is whether or not these sidewalks and curbs on the other side of the street are access facilities or not.
That is a legal question because it's an unambiguous document. And yes, sir, I agree. If they are access facilities, Section 3A says you cannot alter them without the prior written consent of all other owners, which may be withheld in their sole discretion.
Is there a global exception for public safety? Because one of the issues is that if you're going to do this, there's got to be two access. Is there anything that
There,
overlays this that says public safety would trump what your restrictions say in these documents or in the
Justice Sellers, I don't think so in the easement. And to keep this in mind, the requirement for two means of access is peculiar to the design and size of the project the station put on that property. They didn't have to do that. There were a lot of things they could have done where the access to 52nd Street was perfectly sufficient. They chose a particular type of project and configuration and size that in turn required that access. All right, so let me get,
consider if we're evaluating abuse of discretion, which we're talking about doing, can we then overlay any idea about public safety? The court may have considered that and they're considering it or not as an abuse of discretion one way or the other?
the court certainly, he issued a 9-page order. He certainly made no reference to that. I don't believe there was any evidence about that. So I don't think he could have considered that. And again, on abuse of discretion, you first have to start with correct legal rulings, and then you exercise the discretion. The trial court got this easement wrong. So it needs to go back for discretion to be exercised based on a correct interpretation of the easement, not an incorrect interpretation of the easement. So it needs to
I
go.
hate to keep beating, but if it goes back, if we say the court abuses discretion, what result is the court going to do that's going to materially change this development that's substantially
Well,
complete?
there are a number of types of equitable relief the court could give, but first of all, 790 is entitled to a correct interpretation of the easement, period. Even if there's no relief, if the court says, I can't do anything, we're entitled, 790 is entitled to that because there's other property at stake here. But already got my yellow light on, in the Drummond versus, Alabama Power versus Drummond case, where there was a flood easement, the trial court did not grant an injunction requiring Mrs. Drummond to remove part of her house, but it did enter an order requiring her to provide an engineered recontour of her lot to replace the flood storage that was lost by her encroachment. And it also said, if you don't get this done within a year, then you got to remove your house. So the trial court didn't just say, well, I'm not going to do anything. It came up, it fashioned some equitable relief that made sense under the circumstances. That was pretty tough on the infringer, quite frankly, but not as tough as removing her house. So it needs to go back with the trial court to balance equities and decide on relief based on a correct interpretation of the easement, not an incorrect.
Thank you, Mr. Smiley. All right, we're going to take just a short break for the lawyers to shuffle back around, and then we'll be back at 11.
All right. Court is adjourned.